Hello, hi there all. Uh, it is a privilege to have with us an eminent scholar of law and economics, emeritus professor of Hamburg University, Professor Hans-Bernd Schaeffer. I do not think that he deserves an introduction to the world of scholars. Those are doing law and economics or with legal theories or legal analysis. And this conversation will center around of his book, which is going to be published in Hindi translation in India at Indian Institute of Management, Ahmedabad. And we will have a special occasion to introduce Indian audience and Indian readers with this noble thought of book Solomon Knott, How Law Can Reduce the Poverties of the Nation. Professor Schaeffer, I'll start with one thought on the issue of law and economics, that how it came to you and how this came, economic analysis of law, to the world. And then we will come on the issues of this book, how this book came in. So first I would like to know from you that how this movement, economic analysis of law, started and how it influenced you because initially you were a development economist and you started as economist. And then you took up economic analysis of law as a challenge, and thereafter you wrote a lot and you have developed the law and economics in Europe in its initial days. And then you travel to India quite often for a very long time. I hope it is 30 years now. And you're making deliberations on developing law and economics in India also. So how it came to your life and how it does all happen?
Mr. Pandey, let me first say how grateful I am that you took the effort to care for the translation of Bob Kuta's book and my book on economic development and the law called Solomon's Knot. It's a pity that Bob Kuta cannot be here with us today. He's the co-author of this book. I'm pretty certain that it will find an audience in India. It has already an audience, but I think it is very interesting to see that it is now read also by people who read it in Hindi language. So thank you very much again. Well, my experience with law and economics started only in the late 1970s when I was already a professor of economics, but in the law school. We had at the time in Hamburg a new legal education which was aiming to follow an interdisciplinary approach. And therefore, we had in the newly established faculty quite a few social scientists, like we had a criminologist who was a sociologist, we had a sociologist, a political scientist, an economist like me, another economist. So the idea was that modern legal scholarship and modern legal education should be more interdisciplinary and should focus much more than the traditional doctrinal legal work on better understanding the consequences of the law. That was our motto. And this brought me inevitably to law and economics. That was a movement in the United States which was then very fresh, and I was immediately fascinated by the writings of these scholars, especially I started reading the works of Ronald Coase, of course, of Guido Calabresi, and of Richard Posner and some others. And I thought that this fitted very well into our overall concept. Even though I have to say that this concept at the University of Hamburg was much more leftist than law and economics is, but this was not the decisive point. It was much more the view that in the United States a school evolved which brought economics into the study of law, not in a broad sense, let's say the theory of law or something, but a study of the particular doctrinal forms in contract law, in tort law, in property, and so on. This was fascinating, and we started with a group of people, friends from the faculty. We met every week for 2 hours to discuss one of those articles, and that brought me gradually into this field. And then it did not take long that I decided for myself to focus on this development. And I had some colleagues who supported this very well, very much, like Klaus Ott, my later co-author for a textbook on law and economics, but also others like Hein Kötz, to whom I'm very grateful, who wrote a very prominent book on comparative law and who was very supportive to law and economics. He also became later my co-author. And with this support from legal scholars, I had an advantage here in the law school in Hamburg, which many other scholars did not have. I had the immediate contact to legal scholars, and I was in continuous contact with legal scholars, and that influenced my thinking about law and economics, but also my writing very much. But that was the way I gradually moved into law and economics, and then later became active in writing a textbook and making it, better known in Germany. And later on, we established an institute of law and economics at the University of Hamburg, and also a large PhD program, which was then financed by the German Science Foundation. So that it grew over the years. There was a huge growth of these activities in Hamburg, and that goes still on.
So you have witnessed the growth of law and economics in Europe right from its inception. Do you have? I would like to know from you about the first generation of law and economics scholars, and the second generation of law and economics, and then, if I'm not mistaken, we are going to third generation of law and economics. So can you share about this? That how Ronald Coase, Posner, that initial period of law and economics started, and how it has traveled till now with spreading its arms and length in the area of legal scholarship.
Yeah. Well, traditionally in Germany and also in other European countries, legal scholarship is more doctrinal than in the United States. That has a long tradition, and also one has to say that this doctrinal work led legal scholarship in Germany to Olympic levels in the 19th century and also somewhat later. But there was always, also in Germany, traditionally, the view that doctrinal scholarship is not everything, that we have to look at the consequences, at the role of law in society, what does it achieve, what are the policy targets. And if you look at law like this, and less from a doctrinal point of view, when you don't have to ask for the policy targets, then you are in social sciences and in economics. And in the United States, this way of looking at the law in a more what scholars call legal realism, in a more legal realistic way, that scholarship has become very strong already since the 1950s in the United States. So that, I think, explains to some extent why law and economics, the first generation, was in the United States. They had this tradition of legal realism. And another point is that is a feature of the United States culture in a way, is that scholars do not shy away from radical innovation. And I think that Richard Posner, he simply sat down, he wrote a book on the economic analysis of law, in which he investigated all the legal norms we have in civil law, even in criminal law, in administrative law, in competition law, and he looked at them through the economic lens. Whether this was sometimes also criticized and debated and so on, but by this he created a new discipline. I think without Richard Posner, we would not have this discipline. Of course, we would have law and economic scholarship, but not in the sense of a discipline. And he was really a radical innovator. And then, but it spread very quickly, also by the writings of Calabresi, of course, who wrote a very, wonderful works and articles and books on accident law and so on. But this inspired many people, not only in the USA, but around the world. So the second generation, and I can say I'm a part of the second generation. The second generation was already international.
Yes.
I know that some scholars, they say, well, this is just American style and so on, but I think this is totally wrong. Law and economics is a discipline in which we work with insights, research results, methodologies of different disciplines to get a better view on what law is and how the law works, how the law develops, and what the consequences of legal norms are. And this is not, national. That is a general feature of the law, and therefore, I personally, I would regard law and economics, if one wants to compare it with something historical, more to the developments which we had in Europe in the Middle Ages, when legal scholars all of a sudden rediscovered completely new views, new access to law by the resurrection of the Roman law. I think that is more comparable.
Now we come to the little more close to the law and economics.
Yes.
And the obvious question which a scholar of jurisprudence or philosophy of law, when he encounters with the economic analysis of law, this question comes to his mind that why this lens of economic analysis is a little better or much better or more better than the doctrinal lenses of examining law and phenomena of law in the judicial circle or in the policy recommendation or framing the legislation. So why this lens is required and why it is a little bit better than this what we have earlier in many centuries?
Yeah, that's a very important question, and it is not fully resolved so far. You know, when we look at doctrinal scholars who are doctrinal scholars, they look at the legal forms and the benevolent effects of the law are implicit in the legal forms. They are not made explicit. And if you ask doctrinal scholars why they work like this, because everybody would of course say the law should be good for the society, good for the people and so on, but they shy away from making such statements because they say we might not have the information, but we have legal forms which contain such information implicitly. We do not have to make such statements explicitly. And I think as an economist that this legal doctrinal view of the law is very much in line with those with the teaching and with the views of those economists who reject the idea that we can make good predictions on interventions in the society. We can make pattern predictions, but we do not know exactly what is happening if we do something. For instance, Hayek is a prominent figure in that. Friedrich Hayek, Ludwig von Mises also. So if you take their view, then one has to be very careful with making statements about what the effect of a legal norm is. We might not have the information. And if we do not have the information, then I think legal doctrinal thinking is superior to consequentialist thinking. But, you know, I have the highest appreciation for people like Hayek and also for the legal formalists, but we have now much better theories, economic theories with which we can analyze consequences of norms. We have better data sets. We have much more and much better data sets than, for instance, in the 19th century when legal formalism flourished. And we have also much better and easier methods to process such data. You know, we have now many scholars in legal departments who work with econometric methods, a method which only 30, 40 years ago could be used only by trained mathematicians in economic departments. The statisticians, they work with it. Today it is accessible to many, and so we have better theories. We have the methods to process data, and we have the hardware now to process big data, and so we get a pretty much better picture about what the consequences of a norm or of a law is compared to the situation only 30 or might be 100 years ago.
When we analyze these norms and doctrinal laws with such data, then we can have a better recommendation and analysis to have better laws in time to come or near future. And this is the practice which is not available with the traditional school of thinking in legal doctrinal way.
Yes, absolutely. I think that even though the doctrinal legal thinking is important, even today is important, what lawyers call the teleological thinking, that is, we think about the consequences of the norms and whether the consequences are desired consequences from a social policy point of view, that this body of the law which existed before that this becomes much more important, and that law and economics, the discipline of law and economics, is a very important branch of this development. And therefore I think that legal education and legal scholarship should move more in this direction.
I have presented a paper which is being influenced by your book, Solomon Knott. And in that paper I have idea that well order and well-being is connected. So you have a better order and you can improve the well-beingness. Well-being is very badly affected if you suffer from poverty. And poverty is, if it is not a sin, then it is a kind of a great inconvenience. And if it is an inconvenience, then there must be some analysis why this inconvenience occur. And we heard so many economists that there may be economic methods and applications by which we can reduce the poverty. There may be innovations, but there is some contribution by laws to either enhance the poverty or decrease the poverty. How that idea you develop, and how you put this idea that law can reduce the poverties in the nation, and law has a direct nexus with the poverty of the nations.
Yeah, when we talk about poverty in developing countries, we usually mean absolute poverty. That is, people who live from $1 a day or a little more. $1.25 per day is the new line of the poverty line. And I think that today, with the means we have, this is simply a scandal in my view, that we still have about 1 billion people living in poverty, in absolute poverty, and that is not necessary. And it is possible to reduce this poverty or to abolish it completely with the means we have. And some countries are very successful in that. For instance, if you take China, China has contributed most over the last 25, 30 years to the reduction of absolute poverty. According to some estimates, the absolute poverty in China went down by 80%, from 250 million to less now than 50 million people. India, I have to say, is much less successful in this respect for reasons which are for different reasons. The poverty rate, the quota of people in the Indian population living in poverty is declining, so that is a success. But the number of people living in absolute poverty is stagnating somewhat at around between 300 and 350 million people, which is a big lot. But I think it will be a matter of time, of not so much time, that this will be eradicated. And what is a much more complex problem, for which the law plays a big role, that is how nations can grow out of poverty. I mean, in the sense of having more opulence, having in general better living conditions, having also higher incomes and so on. And here the law plays a very big role, at least in the long run. You see, we have, when we wrote this book, Solomon's Knot, Bob Kuta and I, we made some calculations based on long time serious data. Now, we looked, for instance, what was the ratio of per capita income 200 years ago, in the year 1800. We have some data on that. Between the 10 richest countries in the world and the 10 poorest countries in the year 1800. And this ratio was about 4 to 1, or 3 to 1, 4 to 1, roughly that ratio. And if you do the same exercise for the year 2005, which we also did, then this ratio had increased from 4 to 1 to about 60 to 70 to 1. And the reasons for this, there are many reasons. There are reasons which are widely discussed, like imperialism, colonialism, and so on. But I think that the countries which were very successful, they were rule of law countries. And the law could protect investors, they could protect a process which leads to economic growth and to economic development. And in other countries where you have lawlessness and where the rule of law does not exist or is very weak, you don't have these institutions, and consequently countries remain poor. Now, I do not want to be misunderstood. I do not say here that the rule of law is a necessary requirement for economic development.
Yes, because this obvious confusion comes in, that the rule of law is a requirement, a necessary impediment.
No, this is not the case. What we can say is that all rich countries, which are really rich, they have all the rule of law, with some exception, like some small oil countries with a lot of oil. But other countries, you don't find rich countries which have not also developed institutions. But to trigger economic development and to trigger economic growth, for that we found that, and that is the general finding, that the rule of law is not a necessary requirement. What is required for economic development, at least for long periods of economic development, is that investors are protected. But you might have the rule of law, like protect property.
That's what you said in relation to double trust dilemma. That the problem of a trust dilemma can be better resolved by having defined a set of rules. The innovation is possible because the person who invests the money and person who brings the idea, they have mutual faith deficiency. That the investor can think that his money can be stolen away from the person who is bringing the idea. Or person who is bringing the idea may think that the investor can take his idea and he will not be properly paid off. So the innovations are not possible because of this trust dilemma. And what you advocated and what you attempted to say, rather convince your reader that that can be better formulated if you are having a defined set of rules and defined set of laws. How you describe it?
Yeah, well, the starting
and
point
how it is related to poverty.
In economics, we had a very influential theory of economic growth, the neoclassical growth theory, which said that growth comes, and with it the eradication of poverty, growth comes from resource mobilization, that is from, especially from capital accumulation. But today we know that this counts only for roughly 1/3 economic growth, and 2/3 are other factors, and these institutional factors play a very big role. And it is now, I think, common knowledge and agreed knowledge that institutions play a big role, and if we do not have institutions which can protect investors and can protect financiers, creditors, if these institutions are not in place, and if either a creditor can run away with the business ideas of an investor, or the state or some private predator can take the yields from investment away, then you will not have investment in the first place. So what is necessary is investor protection. And as Dani Rodrik, the economist, the institutional economist in the USA, he once put it this way. He said that for economic development, we need investor protection, we need institutions which protect the investors, but he also said that the institutional function does not determine the institutional form. So investor protection can come from substitute institutions, it can come from the rule of law. But at least, for many countries, we can see very positive developments, like in China, for instance, without these countries having a good score regarding the rule of law.
If any country which believe that innovation can be done with startups and advanced form of industrialization or corporate culture, so the better laws are required. And you advocated that the poverty can be reduced by enhancing this culture of innovation in the country with better laws. That's what, if I'm correct, this is how. Then important thing which is there that in the book regarding corruption. Corruption is a big problem in many countries.
Yes.
And corruption in one form or the other form is there, and it has some ethical issues also. And so law has to intervene into that. And sometimes law successfully does it, and sometimes laws are failed to curb the corruption in the. So how you see it in the law and economics perspective, the issue of corruption?
Well, I think the problem of corruption must be seen in a broader perspective. In poor countries like in India or also in China, you have much corruption. In India, you have corruption on all levels of the state. In China, it's more high-level corruption. So that differs from country to country. And in the rich countries, most of the rich countries, like Germany, for instance, we have also corruption, but not, much, much less. But the rich countries have a problem of regulatory capture, which is not corruption in the sense of, that lobbyists are doing something which is illegal, but they sometimes succeed very much in channeling tax money into their coffers, and the effect is similar, With regard to corruption, for some time there was a debate among economists whether corruption is a good thing in some countries, whether you have to pay some speed money to get things done, and mobilize the things. So then some people were a bit lenient about corruption and said, well, without corruption you have no development at all. Things do not move. But I think that is that has now been rejected. We have many empirical research showing that the overall effects of corruption are very bad for the economy. And also this argument of speed money is a flawed theory because it assumes that the level of corruption is somehow fixed by external factors, and then you pay money, to speed things up. But this is erroneous, this is wrong, because the level of corruption is a variable which is dependent on the amount of speed money. So if you have more speed money, then the people in the administration are interested in having more red tape, more regulation, and so on. So that, this is a kind of vicious cycle which the speed money speeds up the demand for red tape, and the red tape brings more speed money and so on. And at the end of the day, it is...
it's endless vicious circle.
It's a vicious circle. Now, when it comes to the causes of corruption, then one has to say, you see, many developing countries do not have a tradition of a civil service. So people, when they work for the civil service, they do not have this idea that they are part of a state, and that they cannot anymore work for their families, for their friends, and so on. I think that takes time, and some countries have this tradition, others do not have this tradition, so it takes time. In our book, we point to one particular precondition of corruption, which leads also to a method to fight corruption. That is, if you have corruption, then you have a briber and a bribee. So it leads to for the corruption, right? And whatever they negotiate, so the briber said, I give you $1 million, the bribee, you get the public offer. And they must trust each other. So what they do, they make a kind of contract, right? Yes. I give you the money and you give me the service. So they must trust each other, otherwise the money would not flow or the service would not flow. And therefore, the briber and the bribee are in a similar situation as someone who tries to make a contract, but the contract is not enforceable. If a briber and a bribee make a contract, they cannot go to court and say, well, the one had a breach of contract.
That's an understanding, not an enforceable contract.
It's a non-enforceable contract. Now, we know from the law and economics literature that non-enforceable contract can be made enforceable if people trust each other. And there are many mechanisms to build up trust. Yes. So if you build up trust, then even you can trust on a non-enforceable contract, right? Yes. But here we have the opposite thing. We have to destroy trust. We have to destroy the preconditions of trust. So if you destroy the trust between the briber and the bribee, then they cannot trust each other anymore, and then they will not. Then becomes too risky to bribe. And I think there are many. I cannot go too much into the details, but there are many propositions have been made by many scholars. For instance, Robert Kuta, he wrote a paper on that. Kaushik Basu wrote a paper, and Nuno Garupa, from the Portuguese law and economics scholar, wrote also a paper. And they have all in common that one has to destroy the possibilities of trust relations.
Trust relations. And this is how we come to see the corruption and poverty, because corruption is also a responsible factor which increase the poverty among the nations. One issue regarding the poverties of the nation is that the comparative poverty among the nations, some life standards that say for instance in China, India and United States, and India is a country where the startups and innovation is gearing up so much. We have example in Silicon Valley where the Bob Cooter is there, and you have taken a lot of examples of this Silicon Valley cultures, how the India is flourishing on that. And since you have traveled to India so much and you have Indian experience, I could have not shared this question with Bob Couters, but certainly you are a right person to answer this. How you see Indian scenario to eradicate the poverty in another 10 years to come? Because you have cited many examples in reference to the country like India, and all the government, one or another, is being elected on the question of growth and development. And being a largest democracy, and we have elections, and this is a difference between China and India, that we have a growth with democracy, and when we have a democracy, then diverse opinions, and sometimes there's a behavioral transgression also. We do not sometimes the democratic process, you do not apply the exactly same rationale as the economist applies. And therefore, there is a deviation on some principles for eradication of the poverty. How you capture this entire phenomena?
Well, let me say first that I personally have the highest appreciation for India. I have been traveling to that country since 1980. It was my first visit. I spent a sabbatical at the Delhi School of Economics, and since then I have continuously traveled and also taught law and economics in Indian universities, and I truly like the country very much. And but of course India is a country not comparable with China. India is such a diverse country. India has many languages. It is regionally very diverse. It has many religions and so on. In China is a much more homogeneous country. And I think what in China you have at the top strong men, who can say, we do this and then it is done. I think in that sense, this is difficult in India. I remember once an interview with your first Prime Minister, Jawaharlal Nehru, who said, so I must remember from my quote from my memory, but what he said was basically that he feels like a little boy sitting on an elephant, and the elephant goes where it wants, but sometimes you might be able to push the elephant in the right direction. Yes. So I think this is a good description even today of how a leading politician in India acts. It's much more difficult, much more diverse. And when I visited India first, you had this planned economy, or you called it the mixed economy, and everything which was important, the coal mines and steel and heavy industry, they were all state-run and subject to planning, and only agriculture and the consumer industries were private. That has completely changed. So India has opened up, and the results, they are tremendous. I mean, India has one of the highest growth rates over the last 20 years in the world. Of course, compared with China, it lagged behind. That is true, but even that has now changed. I think last year India had the highest growth rate in the world, even before China. So by all standards, India is doing very well in terms of growth rates, but it is not doing very well in terms of industrialization and in terms of reducing absolute poverty. And I think the industrialization is the quota of industry, of manufacturing as a quota of the national product, is today not much higher than during independence. The quota, not the absolute amount, but the quota. It is all in most of the growth comes from the service sector. So I think this is a matter of concern because the service sector provides jobs for the well-educated people like you, but not jobs for the semi or unskilled laborers. These jobs can be provided by manufacturing. And I think that is a point on which perhaps India could do more. And, you know, I have discussed this point with colleagues also from India, and they said that one of the bottlenecks for improving the manufacturing sector is the infrastructure, that the infrastructure should be improved.
As far as the infrastructure is concerned, we are rapidly growing to improve, and by and large we have a very good infrastructure. But yes, in having better regulated laws, it is required that law and economics and economic growth is to be taken care of.
Yeah.
Like monopolies, we have recently Competition Commission. And I would like to know from you that how the law and economics tradition deal with intellectual property rights and then monopolies. How you connected this and with a growth story. Being a development economist, how you think that law and economics has given a new eyesight for intellectual property?
Yeah, well, this is a big debate in law and economics. You might know that some of the really important and very interesting research results of the last years are related to this field, intellectual property rights, patents and copyrights and so on. I think that it is a good thing to have all these things, patent law and copyright law. If we look back in the history, for instance, then you find often you have some crazy examples in history what it means or what the consequences are if you don't have this. For instance, I'll give you just two examples. One is this producer, the famous producer, Italian producer of violins, Stradivarius, who lived in the 18th century without patent protection. And he had a manufacturing business. He produced several of such violins, and they are the best in the world, even today. So one single instrument might cost $2 million or more. And when he produced this, but we do not know what the technology was. When his family died, all the knowledge was gone. And even today, we do not know how to produce a Stradivari. And another thing is that, for instance, writers, script writers, they were not protected. People like Shakespeare, for instance, they were not protected at all. Therefore, they gave their scripts to the people, also opera composers, gave it to the singers and then collected it and kept it for themselves, and then later it was lost. So then an important example is, for instance, Jean-Philippe Rameau, who was a great French composer. We know that he composed more than 20 operas, but only 2 of them
are with us.
The rest is gone, So this cannot happen in our system. But there is a growing, I would not say consensus, but there is a growing number of lawyer economists and lawyers who say that intellectual property law is producing more and more adverse effects. And it produces what Heller, the lawyer economist Heller has called the tragedy of the anti-commons. So that if you have upstream inventions or innovations, then all the followers must make contracts with these patent holders or intellectual property holders, and that might be so difficult because transaction costs are high that the patent infringes rather than promotes the production of new knowledge. And therefore there is, this has led to a movement in which we have more use of the fair use doctrine, or we have liability solutions rather than injunctions for users of patents, for owners of such rights. So there's a big discussion about this. Now, when it comes to developing countries like India, then until recently it was quite clear that the distributive effect of intellectual property were, of course, against countries like India, because there was not much research in these countries. So a country like India was always better off when it could freely copy innovations, which it also did very successfully in the medical sector. Yes. Because Indian patent law did not recognize certain patents inside the country, and that led to a huge industry for copied medicine. But now India is in a different situation. It's moving quickly into a different situation because of its large IT sector. India is starting to develop products which it wants to be protected. So I think this automatic conflict of interest between rich countries and poor countries, or let's say better between a country like India or let's say a country like the United States, that is disappearing, and it will disappear the more you have research and development in countries like India, China, and other countries.
So this is how you connected this phenomena of law, growth and poverty, because everybody has a share to contribute in a better steady growth and steady development. Yes, yes. And what is the Solomon knot? Why this Solomon knot?
Well, the name Solomon's knot is from an old Jewish, from a Jewish tradition, and this symbol of Solomon's knot. Perhaps this is the symbol here, which you can see, that symbolizes, trust and love.
Okay.
It symbolizes trust and love. And this is related to the overwhelming importance of establishing trust relations between people for the economic development. We think that this is vital. And now, coming to law, there are two ways of trusting people. You might trust somebody else because you know him, you know that he's trustworthy, perhaps he's a member of your family, and then if he's not trustworthy, then you still have some, means within the family to punish him. So that is the way trust is created. And if you have law, for instance, contract law, then you can even trust people whom you do not know. Because contract law guarantees that if somebody breaches the contract, then he will be sanctioned. He pays you the expectation damages, for instance, for the contract. And this is economically of a very big importance, because if you have a functioning contract law, then you can trust people whom you do not know. Not because you trust them personally, but you trust the legal order. You say, if this guy, if he defects and if he does not do what he has written in the contract, then you can punish him that much that it does not pay out, and you are put in the position as if he had delivered, and this is very important. So I once, in a conversation, I mentioned this to a friend in Delhi who is also a merchant, a good friend whom I know since 30 years now, and I told him about a study in Latin America, I think it was Peru or Colombia. And the author of that study had asked many business people to tell with whom they make business. And these were all friends and family, basically, all people whom they trusted. And then he asked them, now assume you get an offer for, an offer for your business, from a no name, from somebody you do not know. Would you do that? And then he asked the question, how much cheaper must this person be? And then the average answer, they sent around questionnaires, and the average answer must be more than 35% roughly, the price must be less. And you see therefore the economic impact of this, that if you cannot trust people whom you don't know, then these people have no access to the market. It is like a market barrier. It is a barrier to entry. It's a barrier to entry. These people cannot enter the market because they have to offer their products at prices which do not cover costs. Yes. And if they have not the possibility to start, with losses for a long period, then they are simply locked out of the market, even if they are trustworthy. And therefore, a well-functioning contract law moves away an important barrier to entry, which is very important for economic development.
True. This is how you deal with the Solomon knot.
Yeah.
Yes. I came through one article of yours in the book edited by Elias Somin, about the takings.
Yes.
You have discussed taking here in this book also. And you are regularly writing on takings. I hope taking is a very interesting topic of yours, property rights. And taking is a very debatable subject in India also.
Yes.
We have Jamidari Pratha, and then abolition of Jamidari Pratha, and Then the land pieces of land were reorganized, and initially it was a fundamental right, then it became a constitutional right. And when we were together in India, that time the judgment came from West Bengal taking of Tata Group, and public interest issue was changed. So taking is an important issue which has a direct relation with the poverty, because when you have a small piece of land, you cannot irrigate it, you cannot have agriculture better, and industrialists want big piece of land, so they take land out of the people, farmers and all that. The doctrinal approach to the taking is the simple one, that it can be taken up with some sort of a compensation, and public purposes has to be there. But again, the problem, what public purposes will be there, and what kind of a compensation. So lawyers feel always difficulty, and then again consequences comes in, and then again the role of an economist comes in for economic analysis. So taking all this factor in the account, in doctrinal consequences, poverty, issue of growth, and the issue of property rights. So how you see this entire gamut of rights, property rights, growth, poverty, as an economist or as a scholar of economic analysis of law?
It's right what you say, that I'm presently working on taking law, or what in common law countries you say eminent domain law, including in India. In India, I think you say land acquisition. Land acquisition is the right word. And this is very much related to constitutional law and to public law. And that was not my field of specialization. But a couple of years ago, the Korean Development Institute invited me for a talk, and they asked whether I could do something on taking and on eminent domain, which was completely new. But they came up with very precise questions. You know, they had a catalog of 7 questions which they wanted me to answer. So then I became interested in it, and I agreed then to write a paper for the conference there in Seoul, together with other scholars, law and economics scholars. And South Korea is a country which, with regard to this problem, is in a similar situation as in India. Now, you know, in South Korea and in India and many developing countries, in the 1950s, 60s, 70s, you had an economic philosophy of planning.
Yes.
You know, steering the economy from above. And if you have a planned economy, you cannot give private property such a priority. You know, a planned economy, if it should work at all, must have a state, must give the state the right instruments. Now, if you have a developing country, and you know, if it should be developed, then if the state builds schools, colleges, universities, roads, electricity stations, public utilities, harbors, airports, and so on, then you must give the state the authority to take the necessary land for that, right? And if the state then also produces goods which also the markets can produce, you must give him even more power. So this eminent domain power, this very, how to say, this very strong eminent domain power of the state was fully in line with the economic philosophy in the 1950s, let's say. And in India, this has even led, that was a consequence of that, to remove private property as a fundamental right from the constitution.
Yes.
Now, in a market economy, the situation is somewhat different. In a market economy, it is very problematic if the state gets the right to simply take away the land whenever the state thinks it is good for the economy. And therefore, there is, with the move to more market economy, it is also necessary to rethink about the power of the state with regard to taking. And my view is now, which I developed together with an Indian economist. I have just finished the draft of a paper on taking law, an analytical paper with the economist from the Delhi School of Economics, Ram Singh, who is a very knowledgeable economist in this, and we work together and we have developed some ideas. But the bottom line of our papers is that there should be much more judicial control against takings. And for instance, the rationale which is often given that the taking is good for economic development is much too vague. For instance, in Germany, that would not be accepted as legal, as it would be void for vagueness. It would be illegal for vagueness. It must be the reason for a taking should be very specifically described in a law. And that would give also the affected, the farmers or whoever it is, a possibility to go to court and challenge the taking decision by the government. Not just file for better compensation, but challenge the decision as such, the taking decision as such. And it was just coincidental that I was on a conference in India when the Supreme Court of India, the Apex Court, took a very much debated decision to restitute the land for hundreds of thousands of farmers, which were given to the Tata company, and they had to give it back within 24 hours, I think, something like that. And I wrote a newspaper article for an Indian newspaper, and I think that is a step in the right direction, basically.
That judgment you feel,
yes,
you support that judgment. That
yeah, on the conference there was one. I talked also about takings on that conference, and one in the audience asked me, he said, well, but, if the company must give back the land to the farmers, does that not jeopardize or affect negatively the investment level of the country? Doesn't it negatively affect economic development? And my answer was this: of course it can do, but, and he also said, well, Tata could go 300 kilometers to the north in China. This problem does not exist. And then I said, well, if I were a manager of an international firm, then of course I would like, on the one hand, that when I say, I need land in a country, I get it immediately, there is no problem with that. But it can also immediately be taken away again. And I think that all in all, if a country develops some respect for the importance of property for people, then this, at the end of the day, protects also the investor, even if the investor must give the land. But the general investor is better off when his property rights are well protected by the law.
That's what the COSE paper also says. The well-defined property right has to be there.
Yeah, yeah.
And this is how we develop here in the question of eminent dominant taking.
Yes, yes. So, and that I think that can be improved much in India. I have seen in India many pieces of land which were taken some 10 years ago for private purposes, for private development or investment. But I looked at the places, there is nothing.
That has not been then thereafter used or some, that was just an... Definitely, on the question of eminent domain, the perspective of the world is getting changed because of this. This a lot of economists are doing this economic analysis on this issue.
Yes, there was also a kind of ideological thinking. In the 1950s, many people think that private property, that is not a good thing. It is like theft. So private property is theft. But it isn't. It is rightfully regarded as a fundamental human right, I think. And so in India, you have now made, in a way, a full circle from this view that you must give the power to the government to the view now that you have to give more rights to the farmers who are affected by taking decisions.
Professor Schäfer, since 1960s and 50s, till now, the economics has developed a lot. And during 40s and one work on economic behavior, game theories, and choice theories, rational choice, public choice theories, constitutional economics, then institutional economics, and then microeconomic theories. They have grown a lot. So we have many tools available to analyze from economic rationals to analyze the rationals of law, and then consequences which followed by legal implications. And since the world is getting complex, the market is getting complex, and they are merging together from one economy to another economy, which we call phenomena of globalization. David Hult said that it is a subtle invasion in one economy to another. So it has become almost a very complex structure of this entire world feature. And now one country is comparing laws and its implication to another country, and then two countries are comparing their laws with comparative. So comparative studies also are going on, and much data is coming because people are very vigilant about their rights. May it be property rights, may it be tort rights, maybe it be human rights. So we require a higher rational to analyze, and certainly the jurisprudential rational or the doctrinal rational are somewhere lagging behind to have this, and this mathematical analysis, economical mathematical analysis are offering much broader spectrum to analyze this data. So the economic analysis law itself is changing its shape from the inception days, and you have witnessed all this time from the day it is. And when you were the student and now being the emeritus professor and the very renowned established scholar in this field, what do you foresee for another 20 years ahead? What kind of economic analysis we are developing right now, and where we are heading towards? One interesting branch is coming out, the behavioral economics and behavioral law in economics, because in that also we say that the economics and economic analysis of law is about the rationality, and we can keep some rational axioms in picture, and then we have our rational analysis. But people always not behave in that manner, and particularly in democratic setup, when the people vote, sometimes vote, so we have a voting paradox and so on and so forth. So how you foresee that in another 20 years where we are heading towards in terms of a scholarship of law and economics, and how you can foresee that how it is going to shape, and what is the important feature of this shaping law and economics, and what is important thing which is required to be we should consider.
Yes. Well, I think if you compare law and economics as disciplines today, then what you see is economics is an international discipline. So if you study economics, let's say in London or in Boston or in Heidelberg or wherever in the world, in Delhi or in Beijing, it is basically not the same, but roughly it is the same discipline, you know. We have the same questions, we have the same concepts, the same theories, and we work on the same on the same level field. And this is different with law. Law is much more a national cultural discipline. But that was not always the case, and I don't think it has only to do with globalization, because law in Europe, at least, in the whole of what we called Latin Europe, the Catholic, what in the medieval times was Catholic Latin Europe, law was also an international discipline. So if a student studied law, let's say in Oxford or in Paris or in Bologna or in Heidelberg, it was all the same. It was the jus commune, the updated Roman law. And the local law was only studied on the job, training on the job. But the law as such was an international discipline. And that has changed with the area of national codifications, the Code Civil, the Bürgerliches Gesetzbuch in Germany, the Obligationenrecht in Switzerland. So every country had its own law, its own codification, and the consequence of that was that the study of the law and legal scholarship became more national. And it was even difficult for lawyers from different countries to speak to each other, because they used different words, or the same words had different meanings and so on. This is a big problem, and the lawyers themselves have always, or many lawyers have understood this, and this gave rise to the movement of comparative law. So the comparative lawyers, and we have quite a few of them in Hamburg, because we have here the Max Planck Institute for comparative law with some very prominent scholars. They see this as something which should be corrected, and that law should be more international again, and that law students should understand that law is a technique to solve problems. And then it is interesting how other nations solve the same problems with perhaps different concepts. And what I see in the legal scholarship, not so much in the legal education, but in legal scholarship, is a flourishing of comparative law. So my colleague Zimmermann, for instance, who is the director of the Max Planck Institute, is doing huge work on establishing a body of scholarship which is comparative, which is international. And this is a development which I think is much in line with, in a way, even though not from a methodological point of view, but there is some parallel development between this and between law and economics. So I think that the study of law, when we try to understand how corporations function or how intellectual property functions, then the study of law has become much more international.
Yes.
And so I think that would be my answer to the future. And then what you rightly said, there is also the pressure of globalization, which also contributes to a more international perception of legal norms. When it comes to scholarship, then also the interesting developments in law and economics are taking place. When I jumped into this discipline in the 1980s, late 70s, early 1980s, almost all of the scholarship, when you went to a congress or to a workshop, international workshop, then almost all papers were theoretical papers, analytical papers, you know, very often based on microeconomic theory, game theory, and so on. And they arrived at sometimes very, very interesting results, where you could only say, oh, wonderful, well done. And so if you look at the writings of Stephen Chevel, for instance, or Henry Huntsman and others, Bob Kuta also. But in the late 1980s, in the 1990s, things changed very considerably, because we had two new developments. That one was empirical legal studies. So it turned out that more and more lawyer economists and even lawyers who have no background in economics start with doing empirical research in the sense of testing hypotheses with econometric methods. And this is much easier today. It is still difficult, you have to master the econometrics, but it is much, much easier than today. And I know quite a lot of people who were lawyers and had no exposure to statistics or mathematics, who are doing wonderful work. So this is one very important development. The other important development is the behavioral school. As you said correctly, economics is based, or much of economic, especially in microeconomic theory, we use the concept of economic man, which is a person who is rational and who does not regard preferences of others, a selfish actor. And now this behavioral research, which is laboratory research mainly, showed that this is highly questionable, and that people deviate from rational behavior so much that the whole idea of the rational man has come into, has been questioned. I think I have the highest regards for this research, basically done by two Israeli scholars from the University of Jerusalem, Kahneman and Tversky, but it has expanded to a much bigger branch of economic research and psychological research. And this has an impact on law and economics. There's no doubt about this. I'm personally somewhat skeptical about whether the nudging concept, which comes from that, a new kind of paternalistic interference into the actions into the decisions of actors, whether this is really a good and promising method of overcoming such problems and debiasing people. But overall, I think this is a very good development, and we have also in Germany some great scholars who are working on this. For instance, in the Max Planck Institute in Bonn, under the directorship of Engels, who is doing a lot of work in this field. So these are the empirical studies and these behavioral studies. They have enriched the whole discipline a lot, and they were not present when the movement started.
Yes, and the last query. Last year we have established Indian Law and Economic Association, and in India, majority of the law and economics professors or the position holders are somehow one way or the other way a student, or the doctoral student, or somewhere in courses, or somewhere in some supervisory position. We had 3 conferences earlier with IIM, IIT and GNLU consortium. How was your experience, and what you feel that Indian Law and Economics Association can contribute in time to come?
Well,
because the world cannot neglect the fact that India is a big market, and it's a big democracy, and lot of people lives there, and if their life is not better, then the world cannot be better in any ways. So 1/3 contribution comes from us.
Yeah, certainly. Yeah, I'm very glad that this happened, and it is very, how to say, encouraging for me personally also, because some of the people who initiated this in India are former students of mine, and PhD students even, and colleagues whom I know since many years. And I was very pleased when in Mumbai the central bank, which sponsors and finances the Indira Gandhi Institute in Mumbai.
Reserve Bank has funded.
Yes, when the Reserve Bank of India decided, to make a focus there on law and economics. And, that has triggered activities in several universities, like in the National Law School of Bangalore, but also in Hyderabad and in Mumbai and in Kanpur, in the Institute of Technology in Ahmedabad. So it's coming up, and of course it is not easy, because law and economics is different, as we said before, from traditional doctrinal legal scholarship, but it is interesting and very encouraging that it comes up, and I have also the highest regards for some of the research results. For instance, people from the Delhi School of Economics, Ram Singh, are doing very interesting work, but others as well. So I think this is wonderful that it started like this.
And now the book is also coming there for release at IIM, and hope we will be all together there to release that book. And we will be missing Robert Kuter there, and hope he will also be there. And now I would like to conclude this conversation, which is one of the very significant, relevant and contemporary conversation we ever had in the law and economics, with a note, short note, that law is always about rationality, some higher rationality to rule, to create an authority, to put everything in order. That John Rawls also discussed in his book Theory of Justice, that well-ordered society. And then that utopia of that well-ordered society is always haunted to this human civilization. And for that we always require some kind of a rational. And this rational sometimes comes from heaven, sometimes comes from theology, and sometimes comes from a very wise man learned in philosophy of law. But eventually when the society gets complex, market has taken shape into society, it become a market society, and then the poverty issues comes in, then inequality comes in. Then some rational was required, and the right rational is economic analysis of law. And the countries, those are developing, and countries, those have a real urge to develop. If I'm correct me if I'm wrong. Real urge to develop, and they are just running behind the growth and well-being of their people. They cannot live without law and economics. This is the mission, this is the movement which lawyers, judges, academicians has to take together to understand their complex society and their problems, and the consequences of it also, because consequences plays an important part, and this economic rationals gives a very enlightening insight into that. So I wish that this mission will prosper with a scholar like you in another 1, 2, 3 decades. And I would like to thank you from my bottom of my heart and from my people there in India, sitting here at Hamburg, that we enjoyed the conversation, and I hope that the audience who's watching this conversation will be enlightened by some of the ideas which you shared with us. Thank you, Professor Hans-Bernd Schaeffer, being with us and giving us a wonderful talk. Thank you very much.
Thank you.